Y'all can be seated. Okay, you may be seated. Jefferson County Court at Law number 2 is now in session. The court is in session and calls number 23 CCCR 0842. Case is filed in the state of Texas versus Brianna Denise Cobos. Let the record reflect that Ms. Cobos is present with her attorney, Mr. Peter Dole. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. Let the record finally reflect that the jury is now present and seated in the courtroom. State, are you ready to proceed? Defense, are you ready to proceed? Okay. At this time, Ms. Simmons, would you like to present the information? And Ms. Cobos, would you please stand?
In the name and by authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court of Law of Jefferson County, Texas, that in Jefferson County, Texas, Brianna Denise Cobos, hereafter styled the defendant, heretofore on or about May 21st, 2023, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated. It is further presented in and sent to court that at the time of performing an analysis of a specimen of the defendant's breath, the analysis showed an alcohol concentration level of 0.15 or more against the peace and dignity of the state.
Okay. And Ms. Cobos, how do you plead?
Defendant stands mute.
You say she stands mute. Is you pleading guilty or not guilty, or what are you pleading? She's not entering a plea. Well, the court will enter a plea of not guilty on her behalf. You may proceed.
Take place court.
Okay, you may be seated.
Good afternoon. Welcome back. Ladies and gentlemen of the jury, this case is about a choice. And when I say that, this case is about a choice made by the defendant herself, Brianna Denise Cobos, who decided not only to endanger herself, but everyone on the roadway around her. She decided, while intoxicated in the early morning hours of May 21st, 2023, I put the elements up here for y'all to follow along, that she was going to become intoxicated, get behind the wheel of her motor vehicle, and operate her vehicle in a public place. Ladies and gentlemen, these are the same roads that you travel every single day. Same roads that you travel to maybe drop your kids off at school, pick them back up and bring them back home. The same roads that you travel to get here today. Our concern when we're trying these DWI cases is not only the safety of the defendant, but the safety of your well-being, the community around us, and your children, anybody. Bringing it to the point, on May 21st, 2023, Brianna Cobos, again, I want to reiterate, chose to drive while intoxicated in a public place, operating a motor vehicle while intoxicated, and I anticipate the evidence will show you that that alcohol concentration level was 0.15 or more. I anticipate the evidence will show you that while she was operating a motor vehicle on a public highway, State Trooper Jeremy Fairway, which you'll hear from him today, is on the side of the road. He sees Brianna Cobos swerve off to the side onto the shoulder, get back into her lane of travel, swerve all the way into another, get right back into the right lane. And as she's doing this, he knows there is a rear defective tail light in the back. At that time, the officer, or trooper, however you want to call him, you can use them synonymously, he decides to initiate a traffic stop. He follows Brianna Cobos to a safe location. That safe location is at a gas station in Jefferson County, Texas. I anticipate the evidence will show that it's very well lit, level to walk, easy to see. Evidence you're gonna be able to see, I anticipate will show, and this is through use of exhibits such as body cam, dash cam, witness testimony, which we talked about referring to as evidence itself. You're gonna hear that when he approached the defendant, he'll testify to this and you will hear this. He asked for the driver's license, to which she responded, "I was driving drunk." Cause for concern. Evidence is going to show you slurred speech. He decides there's a matter of safety at concern here. He asked her to remove herself from the vehicle and they performed standardized field sobriety tests. You probably heard that used synonymously with SFSTs. So if you hear me say DAC for blood alcohol concentration or SFSTs, that's what I'm referring to. What Officer Caraway or Trooper Caraway is looking for in during the standardized field sobriety test is clues, indicators of intoxication. After he goes through and performs all these 3 tests, he sees that there's clues and signs of intoxication. He then places the defendant under arrest for driving while intoxicated. Later on, after they go to jail, he asks if she's willing to consent to a blood, or not blood, I apologize, but breath, and she consents. Upon that report, I anticipate the evidence will then show that it was greater than not only 0.08, but greater than 0.15. And after you hear from Trooper Caraway, you're going to hear from Steve Mays. He is the technical supervisor. He's going to come in, he's going to testify to his education, his experience, the scientific theory behind intoxilizers. And then he's going to testify to the results himself. Ladies and gentlemen, you will get to see all this. It is your job to pay close attention to the facts before you. You'll get to see all the evidence in which I'm talking about. And I truly ask that you pay close attention and understand that we are here to hold the defendant accountable for her actions. With that, I want you to think about these roadways. This is your home. These are the same roadways you put your children on, your family. I ask that you hold the defendant accountable. I look forward to presenting this case to you. Thank you.
Okay. Mr. Dahl?
Judge,
You may proceed.
I think, so y'all, Pete Doyle, here at Doyle Jr. And I have practiced law in and around the state of Texas for a number of years. And each case that I've tried cases, that really is like an individual case. They're never all the same. And what I've learned over the years is that what I'm really trying to do is to make the state prove each and every element of its case beyond a reasonable doubt. I mean, if you don't prove all of the elements of the case, then they should be not convicted, they should be acquitted. So that's really what I do. As an entered plea, we're just here to see if the state can prove each and every element of the case to help you, because the state had a list of elements. I'm looking at the same information, that's the paper they used to charge it with a crime. And I came up with 7 elements. On or about May 21st, 2003. That's an element. Then and there, that's an element. Operate, that's an element. A motor vehicle, that's an element. In a public place, that's an element. While the defendant was intoxicated, that's an element. And at the time the defendant, at the time of the offense, the breath sample showed that she scored, made, or whatever, registered a 0.15 or higher on the breath test. Those are all the elements they have to prove. If they can't prove, for example, that someone was driving in a non-public place, like on a range, in a park. They aren't making an element of the public place unless that becomes a big part of the place. Like WJ driving in the street. Me driving in the beach. We have to prove that it's a public place, that it's accessible, all the things like that. And has to be a motor vehicle. Has to be a car, a truck, something that has an engine that propels the vehicle. Can't be a bicycle, can't be a. I don't know if it means walking. You know, people are riding around the cities and stuff because they're that funny. I don't know if those would qualify. That's not enough here. Right? That she has to have been operating, that means the vehicle has to have been within her control. And she hasn't been able to manipulate it. And I don't think there's gonna be any doubt about the May 21st date, so that's nothing to worry about. But in the way the system's set up, the way the legal there is, they have to prove each and every one of those elements. If they do, then you're obligated to return a verdict of guilty. If they don't, and they don't do it for each one of them individually, then by your oath that you've taken, you're not supposed to vote for guilty, you're not supposed to vote for a conviction. Because they have to prove each and every element to each and every person on the jury. Now, the only thing that I can think of other than that, and say that we're here to see, make sure the state does its duty, is where you case was. So I'm going to be asking the officer where the case was because I'm kind of confused about that. But that's just for the trial. And I asked y'all to be patient. We're going to go through it, see if they prove to your satisfaction each and every element, and then we're going to return. And it bothers some people. So I just try to tell them ahead of time, y'all are going to have to decide punishment. Y'all just have to decide your evidence. And if you decide, well, then you're going to go to the judge. So that's what your duty is. That's your job. I would guess it would finish tomorrow morning. I don't know. It could go quicker than that. But thank you for your attention.
Okay. Ms. Simmons, would you like to call your first witness?
Yes, sir. State calls Jeremy Caraway.
Jeremy, what? That's fine. Yes. True, Carol, would you please come forward? Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. You may put your hand down and you can take your stand. Oh.
Just again for the record, could you go ahead and state your name?
Jeremy Caraway.
And how are you presently employed? Are you a certified police officer?
Yes, ma'am.
And just so we're clear for the jury, you're often referred to as a state trooper, would that be correct?
Yes, ma'am.
And how long have you been with the Texas Department of Public Safety?
Over 22 years.
Can you explain to the jury your duties with DPS?
Currently, I'm in commercial vehicle enforcement. We also enforce state traffic laws, investigate crashes, DWI enforcement, criminal interdiction, those topics.
Can you explain your educational background?
I have a bachelor's degree in criminal justice from Lamar, and I have a master police officer's license through state.
Okay. And do you or have you had any special training as to your duties as a police officer?
Yes, ma'am.
Okay, and what are those?
We go through 6 months at the academy in Austin. After we get hired, we go through various courses, traffic law enforcement, law enforcement, SFSD training, and toxicology certifications.
Have you had any specialized training pertaining to detecting any signs of intoxication?
Yes.
And what kind of training have you had there?
Well, most recently is the recertification. So in toxicology and SFSTs have to be recertified every other year. So some toxicology was August of 2023, and the SFST recertification was October.
So just to be clear, you are presently certified on everything.
Yes, ma'am.
Now, were you deployed or employed with DPS on May 21st of 2023?
Yes, ma'am.
Were you on shift that night?
Yes, ma'am.
And what were your duties on that shift?
Traffic enforcement, crash, working crashes, DUI enforcement, traffic law.
Were you working along that night?
Yes, ma'am.
And in the early morning, I want to say around 1:20 a.m., did you observe anything out of the ordinary?
Yes, ma'am.
And what did you observe?
Observed a silver Hyundai car, driving on an improved shoulder were prohibited, and also had a defective brake light.
Just for clarification, is that a motor vehicle in the state of Texas?
Yes, ma'am.
Did you see the driver, or do you see the driver of that car in courtroom today?
Yes, ma'am.
Can you identify her by an article of clothing?
Yes, she has like a tan colored jacket, white. Part of the white jacket.
Your Honor, may the record reflect that he has identified the defendant in this case.
The record will so reflect.
When you first observed the defendant's car, where was it that they were traveling?
Southbound on Twin City Highway, around Fifth Avenue, Jefferson County.
Is that a public place?
Yes, ma'am.
And that's in Jefferson County?
Yes, ma'am.
Okay. Can you describe the condition of the road that day?
It was clear, was not raining. It was nighttime, kind of a well-lit area.
Do you recall if it had rained at any that day?
No, ma'am.
Can you explain to the jury where your car was in relation to the defendant's car, what upon observation?
Upon observation, I was behind the defendant's car, traveling in the same direction. She was in the right-hand lane, to the outside lane. I was behind her and it was her violations.
Okay. Is it at that point you used your sole discretion as an officer to initiate a traffic stop?
Yes, ma'am.
Okay. And where did the defendant actually stop when you initiated it?
She stopped in a parking lot, Chevron parking lot on Twin City and First Ave.
Can you tell the jury how you approached the vehicle?
Yes, ma'am. It was a pretty well-lit area. Approached the vehicle on the driver's side, with a flashlight to identify myself as a police officer and told her the reason why she had been stopped.
When you approached, was it the defendant that was sitting in the driver's seat?
Yes, ma'am.
Was she the sole occupant?
Yes, ma'am.
Did you ask for her driver's license?
I did.
How did she respond?
She presented a Lamar University identification card first.
Did she make any statements that were of concern to you?
Yes, ma'am. She said she, was driving drunk and she's.
Can you describe, I'm sorry, go
Yeah,
ahead.
it's fine.
Can you describe to the jury her response or her speech?
Her speech was slurred. I noticed that she had bloodshot and glassy eyes.
Okay. Did you ask the defendant at that time to step out of the vehicle?
Yes.
And did she do so?
Yes, ma'am.
Can you describe to the jury how she was acting upon stepping out of the vehicle?
So, she stepped out and asked her to step to the rear of her vehicle, and as she was doing, she was using her car for balance, and staying on her feet.
Is that considered the loss of balance? Is that considered a sign of intoxication?
Yes, ma'am.
Your Honor, may I approach?
Yes,
I'm handing you what's been marked as State's Exhibit number 1. Do you recognize this?
Yes, ma'am.
Are you familiar with this exhibit? Have you had a chance to review its contents prior to trial today? Can you tell me the recording device it was recorded on?
It's a body
Okay.
camera.
Was it functioning properly at the time?
Yes, ma'am.
And are you a competent operator?
Yes, ma'am.
Has there been any alterations to your knowledge to this?
No, ma'am.
I'm going to approach and tender this to your defense counsel for inspection.
Okay.
He said no objection.
no objections at State's Exhibit number 1?
Permission to publish?
Yes, you may.
Is it normal for your body cam not to become active in audio up until a certain time?
That's correct. Yes,
At
ma'am.
what point in time, Becky?
Usually it's around 2 minutes. It may be a little bit shorter period of time, body cameras. It'll record before the actual lights come on, and when they come on is when the audio. Joe, how you doing? Joe, the reason why I stopped today, you were driving on the shoulder a while ago. Also, you have a brake light out. Yes, ma'am. Do you have a driving license with you?
Starting driving. I'm not.
Okay, let's start with your driver's license first. Ma'am,
I'm not my journey.
okay. That's your credit card, student ID, okay. Do you have your regular ID in there? Or? Okay, you put your first down, can you come back here for just a minute? Alright. You just put your purse in your seat there and come out here for just a minute. Yeah, I'll meet you back behind your car right there. Okay. You okay? All right. Not really. So where do you come from tonight?
A quinceañera.
The quinceanera, where?
Compro something, Compro Center.
Okay. And, so how much have you had to drink tonight?
No, I have no idea. I think I need 3 shots and then 2 West balls.
3 shots and 2 buzz balls? Okay. When's the last time you had a drink?
Maybe like, not even 30 minutes ago.
Not even 30 minutes ago? Okay.
So I need to calm down.
Okay, let's come over here. I want to check your eyes real quick.
Is it normal upon approaching a vehicle and the driver might be suspected of a DWI? Is it normal for them to pull something out outside of their driver's license when asked?
Yes, ma'am.
Okay. Does that give you any indication of intoxication?
It's one of the indicators.
Did she struggle to find her driver's license here? Did you ever end up actually obtaining it?
Yes, ma'am.
Now, at any point in time after this transaction right here, with dispute, you asked the defendant to perform standardized field sobriety tests?
Yes, ma'am.
And did the defendant appear to be injured or disabled?
No.
Did she make any statements as to a disability she might have?
No.
What test did you have the defendant perform?
What's called the horizontal gaze nystagmus, and walking burn, and then one leg stand.
Can you explain to the jury, just for their understanding, what SFSTs are, or standardized field sobriety tests are?
They're standardized tests that we're putting to let an officer conduct these tests to determine if the subject is intoxicated. Basically, in a nutshell. You want me to describe each one of them?
If you don't mind.
Sure. So what's called the horizontal gaze nystagmus, I know y'all probably just heard of it called the pen test or the finger test. What we do is test the eyes to determine if they have nystagmus, which nystagmus is involuntary jerking of the eyes as it goes to the side to side. So we do that test in the walk and turn. We'll have them perform, walking 9 steps forward, 9 steps back while they have their arms down by their side. I can go through the whole test, presume if you want me to explain the whole
We'll
thing.
break it down as we get there. Can you explain that last test?
So the last test is the 1 leg stand. Y'all probably seen that done where you put 1 leg on the ground, lift the other one up about 6 inches off the ground while you can maintain your balance, and you got to count out loud. It's a standardized test for field sobriety.
Are these 3 tests performed back to back to back?
Yes, ma'am.
Okay. What was the first test you conducted for this individual?
Horizontal gaze nystagmus.
Did you demonstrate or explain how the test worked?
Yes, ma'am.
Did she indicate that she understood your instructions?
Yes.
Okay. Did she attempt to perform the test?
Yes, ma'am.
Was she able to successfully complete it?
Yes.
What is something you're looking for within the HGN test?
So there's three different clues for a total with both eyes, so total of 6 clues. If you have 4 of the 6, the likelihood of them would be intoxicated is very high. So first clue is lack of smooth pursuit. Second one is distinct and sustained nystagmus and maximum deviation. Third one is onset of nystagmus prior to 45 minutes.
Did you see any of these clues or any indicators of these clues in the HGN?
All 6.
You saw all 6. Okay. In your opinion, does it maybe diminish the reliability if the defendant is nervous or has never conducted an HGN test before?
Why would you bring that?
I can. In your opinion, does it diminish the reliability if the defendant may be nervous or has never completed that test before?
No, ma'am.
Forgive me, I talk fast at times. Okay. What was the second test you performed?
The walk and turn.
Did you explain to the defendant how that test was to be performed?
Yes, ma'am.
Did she indicate that she understood?
Yes, ma'am.
Can you explain to the jury what it is you're looking for in this test?
So basically, there's 8 clues with the walk and turn. I have them put their arms down by their side and imagine there's a line straight in front of them. They have to walk heel to toe with their arms down by their side, looking down to their feet while they're counting out on 3. And also, when you get to the 9th step, you're going to keep the lead foot on the line. You're going to take several small steps to make a turn and walk the same 9 steps back to the way that they came. Arms down by the side, looking down at your feet, counting out loud.
Did you see any of these clues or indicators on the defendant that night? Okay. Do you recall which ones you saw?
I saw can't maintain balance during instruction, missed heel to toe, stepped off line, the wrong number of steps, and an improper turn. There are 5 of the 8 clues.
5 of the 8.
Yes, ma'am.
Okay. What was the third test you performed?
Third test is called 1 leg stand. So basically, you put your arms down by your side. You lift the leg of your choice. You lift it straight out, not bent. You'll do that about 6 inches off the ground where you point a toe down, pointed downward like parallel. So you gotta look down at your foot, count out loud, like 1,001, 1,002, 1,003, so on.
And again, for this test, did you explain to the defendant how it was to be performed?
Yes, ma'am.
Did she indicate that she understood?
Yes, ma'am.
What kind of clues are you looking for here?
So we're looking for swaying, hopping, put your foot down, or use arms for balance.
Did the defendant show any of these clues?
Yes, ma'am.
Do you recall which?
She swayed, put her foot down, and used arms for balance.
Okay. Following the completion of these standardized field tests, with your experience, did you place the defendant under arrest for the offense of driving while intoxicated? Okay. I'm gonna play a little more of that video.
I can get you a stand right there in front of my car, and we'll turn these overhead lights off, just right there. Let's see. You can see it right there, doesn't it? All right, so do you wear contacts?
No,
No, okay. Can I get you a stand right here and face, stand right there and face me? Actually, get you a stand right here. And turn around and face me, please. All right, so you do not wear contacts, correct?
no, I don't.
Okay, can I get you to put your feet together, arms down by your side for me? Okay, you see the very top of my pen right here?
Yes,
I want you to follow the top of my pen with your eyes only.
okay.
Do not move the head, you understand?
Mhm.
Just don't move your head, keep your head straight, just move your eyes, okay? Just keep your head straight, just your head's facing me and move just your eyes, okay? Just your eyes. Just your eyes, still move your head, move your eyes, just your eyes only.
Never gotten it before.
Okay,
I've never gotten checked.
okay, just a little bit more. All right, then go up and down, okay? Okay, you come over here for me? All right, if I can get you standing right here, face my car, okay? Okay, for me. Okay, if we're gonna do a walking test, would you like to do this with your shoes on or your shoes off, since you have, those kind of shoes?
I got shoes off.
Shoes off, okay. Okay. All right, what I want you to do is imagine there's a line straight in front of your left toe, in front of your left foot towards my control car, okay?
Okay,
With your left foot on that line, I want you to put your right foot in front of your left, touching heel to toe.
Okay.
All I want you to do is keep your arms down by your side and don't do anything else that I tell you to, you understand?
yes.
When I tell you to, I want you to take 9 steps forward, heel to toe. Once you get to 9, keep your lead foot on the line, take several small steps, make a turn. Walk 9 steps, heel to toe, back down the same line, with your arms down by your side, looking down at your feet, counting out loud. It's gonna go like this, okay? 1, 2, 3, and so on, all the way till you get to 9. Now, if this is your number 9 step, keep your lead foot on the line, take several small steps, just like this, okay? And then walk 9 steps heel to toe, back down the same line, with your arms down by your side, looking down at your feet, counting out loud where I can hear you, okay? Now, it's important, once you start the test, don't stop till you finish. Okay, do you understand all the instructions?
Yes.
Okay, all right, whenever you're ready. Now, count out loud. Okay, make sure you count out loud while you're looking down at your foot.
1, 2. 3. 4. 5. 6.
That's off mile 6. Let's go to
7.
8. 3, 4 inches, 7.
9.
No, no. Okay,
2, 3, 4, 5, 7, 8, 9.
okay.
And 9.
Okay, all right, let's come over here and do one more, okay? You probably wanna do this from without your shoes too. All right, that's good, let's do it right there. Just face my car, put your feet together, arms down by your side. Now, what I want you to do you want to left or right, doesn't matter.
Left.
Okay, what I want you to do is lift that leg up about 6 inches up off the ground. Hold on, let me show you how to do it first and explain everything to you first, okay?
Mhm.
Want you to lift your leg up, keep your arms down by your side, point your toe downward where it's parallel to the ground. Want you to count out loud in thousands, okay? Where I can hear you, okay? 1,001, 1,002, 1,003, 1,004, 1,005, 1,006. If you continue counting till you stop, okay? You understand all the instructions?
Yeah,
Are you sure?
yes.
Okay. Whenever you're ready. No, hold on, you're gonna face this way.
This
You're gonna face this way. Yeah, did you watch how I did it?
that's one,
no, like this.
that's two.
Look straight out in front of you with your legs straight, arms down by your side, looking down at your foot, counting out loud, okay? Do you understand all those instructions?
Mhm. 1,000 what?
1,001, 1,002, 1,003, 1,004, you're gonna continue like that,
Okay.
okay? You understand?
No, they set me up, dude. They set me up because I knew that like, as soon as I was this quinceañera, that I was gonna be done for it. 1,001, 1,002,
You gotta lift your foot up though,
1,001,
about 6
1,002.
inches.
That,
Continue counting. You stopped on 1,002, continue counting.
1,001, 1,002, 1,003,
We're down to your foot where you can.
1,004, 1,005.
Okay. That's good. So I'm put your hand on your back for me and the rest. For a, okay.
Commissioner Purcell, please.
Yes.
At this time, I'm handing you what's been marked State's Exhibit number 2. Are you familiar with this?
Yes, ma'am.
Have you reviewed its contents prior to trial today?
Not today.
Okay. Would you recall if you had reviewed them?
Yes,
Do you need a moment to review them?
No, ma'am.
Okay. What was the recording device it was
It
used?
was my dash camera from my patrol car.
Was it functioning properly at that time?
Yes, ma'am.
Are you a competent operator?
Yes,
Okay. Has it been altered to? Submit this to defense for inspection?
No objections?
No, no objection.
Okay,
Permission to publish.
yeah, the state's exhibit 2 is in, you may publish it.
That video recording. Is this the dash cam to your unit on May 21st, 2023?
Yes, ma'am. The last time on as well.
You're referring to audio?
Correct. Yes, ma'am.
At this point in time, to be clear, is this the defendant's vehicle?
Sure.
Were you able to see it?
No, I can see it, but there might be a couple of cars that. Yes, ma'am.
Can you confirm whether or not this was the defendant's vehicle you were following the entirety of the time?
Yes, ma'am.
And can you explain to the jury where you see the defective rear tail light?
Yes, ma'am, it's on the right side.
Okay, is it that middle portion right there?
That's hard to tell from this point. It looks like the middle portion, yes, ma'am.
But that is the defective rear tail light, which you refer to?
Yes, ma'am. The brake light, yes, ma'am.
I'm gonna fast forward this just a little bit. The jury understands. Can you explain that this dash cam is working at the same time as your body cam is working?
That's correct. It's working. I can't pick up the audio, but the only audio that you get from the dash cam is on the inside.
Right here, would you say the dash provides a better visual for you to see when the defendant might be swaying? I noticed you have the defendant turn away from the vehicle. Is that to have her turn away from any of the lights that might be protruding from the vehicle? Okay, and why is that?
The flashlights can cause the stagnant, so we want to turn those flashlights off.
thing you previously testified to was the fact that the defendant can't maintain balance during construction.
Yes, ma'am.
Is that something you're able to better visualize here with your dash cam?
Yes, ma'am.
Along with the stepping off of the line,
Yes, ma'am.
the missed heel to toe? The improper turn? That also help you to visualize the wrong number of steps. What test are you preparing for now? At this point in time, are you placing the defendant under arrest?
Yes, ma'am.
Typically, it's in the front seat of my patrol car.
Do you have a camera in that front seat? Your Honor, may I approach?
Yes.
I'm showing you what's been marked as State's Exhibit 3. Are you familiar with this exhibit?
Yes, ma'am.
And what is it that it is reported with?
It's the front seat camera on my patrol car.
Was it working properly and functioning properly at that time? Okay. Has it been altered in any manner? And does it true or fairly and accurately depict the events that portrayed?
Yes, ma'am.
Tendering to the defense order section, State's Exhibit 3.
Oh, no,
No objections?
no, I'm sorry, no.
Okay, no objections. State's exhibit number 3 is admitted.
Permission to publish.
Yes, you may.
This one will be really quick, okay? And this is accurately reflecting the front seat of your.
Yes, ma'am.
Defendant waiting in the front seat of the car. Are you performing what is known to be an inventory to the vehicle?
Yes, ma'am.
Do you find anything in the vehicle of concern?
Two empty buzzball containers of alcohol.
Okay. Later on during the night, did you ask the defendant to provide a breath sample?
Yes, ma'am.
And did she consent?
Yes, ma'am.
Can you go ahead and tell the jury how toxilizer operators are certified?
So we go through a pretty lengthy course. I'm not sure how many hours, almost a week, with the toxicology course. They teach us how to operate the toxicology, and then there's actual people that come in and get to the levels of intoxication so we can perform the toxicology on them. With the intoxicated level, level different.
How long have you been off the like for certified as an toxilizer?
Oh, same time as I've been in software over 22 years.
You said over 22 years.
Yes, ma'am.
Okay. Do you have your current certificate?
Yes, ma'am.
Okay. Have you had any special training or attended any specialized courses pertaining to the toxilizer?
Just, brief after over 2 years.
Can you- I apologize. Can you say to the jury who performed that course?
It's, given by Jefferson County, scientific advisors in Jefferson County.
And were you certified as an intoxicator operator upon the completion of that course?
Yes, ma'am.
Do you presently hold a certificate from the Texas Department of Public Safety as a qualified operator of the intoxilizer instrument? And how often must you be recertified?
Every year, you're supposed to do at least 5, tests on the toxicology. It can be either 5 tests by subject, like UWI enforcement type stuff. Or you can do 5 practice tests, or you can do the combination of both put together. Whichever you get to first, basically.
When were you last certified?
Last year.
Okay, do you recall the date?
Well, so the class, so we also, every 2 years, we have a class, an in-person class. That was in, August of 2023. That same year, I did 5 tests, either I can't remember if it was practice or field study tests. In addition to that, last year in 2024, I did 5 practice tests as well.
Were you certified on May 21st, 2023?
Yes, ma'am.
And you were working on that shift, correct? Okay. I'm gonna kind of direct your attention to about 2:30 a.m. Did you have an occasion to administer an intoxicator test to the defendant before you?
Yes, ma'am.
Do you see her in the courtroom?
Yes, ma'am.
And just to make sure it's the same person you had identified earlier as the defendant?
Yes, ma'am.
Prior to administering the test, was she in your presence continuously for 15 minutes?
Yes, ma'am.
Is there a reason that's done?
Just in case there's, something that's introduced into their system or their mouth, to eliminate residual alcohol. Typically that's done within 15 minutes. If they burp or vomit or something like that, for reasons like that.
Did any of those things occur during that 15-minute period? Before actually conducting the intoxilizer report, did you check to see if the defendant had anything in her mouth?
Correct. Yes, ma'am. I checked.
Okay. Can you explain to the jury what type of intoxilizer you used?
The intoxilizer 9000 is the Jefferson County Jail.
Do you recall the serial number on that?
90-001883.
Okay. And can you go ahead and tell the jury how the intoxilizer test is performed?
So what you do first is it goes through a warm-up period, and then you enter the subject information. you enter your own information, like my certification number. And then it goes through a series of operational tests. After that, it clears out the system. It basically blanks it to where it's ready for a test
Okay.
for the subject introduced.
I'm showing you what's been marked as for identification purpose as State's Exhibit 4. Do you recognize this?
Yes, ma'am.
Can you tell me whose name is at the bottom of the signature or at the bottom?
Oh, that's,
So you actually conducted this intoxilizer report.
yes, ma'am.
While conducting this test, did you enter the subject's name and any other identifying information?
Yes, ma'am.
Okay. And what information was printed by the instrument on State's Exhibit 4?
The subject's name and the date of birth.
And those are just standard identifying information?
Yes, ma'am.
Is that how you're able to connect the intoxilizer to the defendant?
Correct. Yes, ma'am.
Does the technical supervisor review this report?
Yes, ma'am.
Okay. And do you recall who the technical supervisor was?
I think it was Stephen Mays. That was last name.
How was the date and time the test entered on the the analytical report?
After each portion of the sequence of analysis, a time is entered.
Okay.
Yes, ma'am.
Would you say the intoxilizer report is self-calibrating?
Yes, ma'am.
At any point in time, do you have to calibrate it yourself?
No, ma'am.
Are the results, or as part of the automatic operation of the intoxilizer report, does the instrument perform any type of operating system check before each test?
Yes, ma'am. It's
Okay.
basically blank. It's called an air blank. It does its internal test. It calibrates the temperature, does an air blank. Subject administers performs their breath. It records it, it goes through a blank, and then it goes through the.
Are the results of the circuit exam that we're going through, and I believe that's a 14-step process, are those entered onto the report?
Yes, ma'am.
Okay, and do you recall what the report was?
The actual results.
Correct.
So the first result was 0.233, and the second result was 0.224.
Do you recall what the predicated value for the calibrated verification solution was?
The solution temperature,
Correct.
34.01 degrees Celsius.
Let me take this back. At any point in time, if there's an error for the intoxilizer report, would it show that?
Yes, ma'am, it would show it. It would stop at best if there was a problem.
Would it make any type of indicator on the report as to its failed completion? Do you know what it would say?
It just depends. It depends on, if it's elevated temperature, it could be one thing, it'll stop the test. It won't let you enter subjects, breath analysis. If the subject like says, yes, I'll give you breath, but then after you start the sequence and they say, no, I don't want to do it, you have to push the stop button. It'll say, just forget what the wording is on it. Invalid test or stop the test or something.
So no results would show if the test was not performed correctly.
That's correct. Yes.
So if a complete analytical report was made, does that mean every part of the sequence was completed properly?
Yes, ma'am.
Did you get a test result on the test run on the defendant?
Yes, ma'am.
And do you have an opinion as to whether the intoxilizer, and that's instrument, it's the intoxilizer 9000, serial number 90-001883 was functioning properly?
Yeah.
And this is when we're talking about Exhibit 4.
Yes, ma'am.
Okay, what's that opinion?
I believe it was operating correctly. She introduced her breath 2 different times, and she was over the legal limit of intoxication in the state of Texas.
Have you had an occasion in the past to run intoxilizer reports
Yes,
on
ma'am.
suspects?
Yes, ma'am.
And you recall about how many?
Oh,
It's been 22 years,
it's been a
so
while. Probably a
couple hundred.
Yes, ma'am.
Have you had an opportunity to observe intoxicated individuals in the past?
Yes, ma'am.
One, few, or many occasions? Many. And based upon your experience and your observations of the defendant, did you form an opinion as to whether this defendant was intoxicated when in your presence?
Yes, ma'am. I believe she was intoxicated.
Okay. And you have testified you were certified as a qualified operator of the intoxilizer instrument 9000?
Yes, ma'am.
Are you telling the jury that you're qualified to test about the underlying theory?
Yes, ma'am.
Okay. And who would be the person qualified to testify on those matters?
That would be a scientific advisor.
Is that who you referred to earlier?
Yes, ma'am.
And that was Steve Mays?
Stephen Mays.
There are no further questions for the witness.
Okay. At this time, ladies and gentlemen, we're gonna take a 5-minute break. So, everyone, please stand as the jury exit the courtroom. Court will be in recess. You may be seated. Court is back in session and calls number 23 CCCR 0842, case of style of state of Texas versus Brianna Denise Cobos. Let the record reflect that Ms. Cobos is present in court with her attorney, Attorney Peter Dahl. State is present with Assistant Criminal District Attorneys, Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. Let the record also reflect that the jury is now present and seated in the courtroom. And Ms. Simmons, you passed witness, is that correct?
That's correct, Your Honor.
Mr. Dahl, the witness is yours.
You put it in the court.
Yes.
Are you?
Good, sir, how are you?
I'm pretty fair. Look, I have some general questions and then I'll be more specific based on the answers are to the general questions. Okay. Right. This is sometime in May the 21st.
Yes, sir.
When the video starts, you're parked on the side of the road.
That's correct.
Is it an individual preference or are y'all rotating through the night? Like when do you go on shift?
That night, probably went on shift at 4 p.m. Supposed to get off at 2 a.m. from that shift that night.
So you were close to the end of your shift, right?
Yes, sir.
Did you park on the side of the road because that's where you'd been all night, or do y'all like park and then drive around
Oh, no, so we drive around different locations, yes, sir.
during the course of the night?
Yes, sir.
So you're parked on the side of the road and the car passes. And you don't have any observable reason to pull her over except for the taillight?
Well, the reason why you might not be able to see, her driving on the shoulder is she may have done it before she passed me. Because I often look, when I'm sitting on the side of the road, I'm often looking in my mirrors to see if vehicles come over. Because if they come over on the shoulder, then I gotta have time to get out of the way before they hit me. She may not have been close enough in that case to hit me, but that's another reason why I check the mirrors also as well.
That would be your
Yes, sir.
caution.
That's correct, that's correct.
But you can't remember if she did that night, or you don't just consider
I
it
didn't
a
see
habit?
it on the video, so if I put that as one of my probable cause, reasons to stop, it must have been before she passed me. And so you're not gonna see it on video.
Okay, well, I didn't, so
I
that's why I
didn't see
was
it. Correct, yes, sir.
So where were you about? Like, were you
I
near the
was on-
embers?
Sir,
Were you near the embers?
I was close to it, yeah. Well, no, not the embers. I was a little bit closer towards Beaumont, probably close to, what's that other little, place, Tammy's maybe? Like 9th Avenue or
Okay,
a street north of that maybe.
all right. And the reason that you were parked there was because it's advantageous or something, or you wanted to see if anybody leaving the club or whatever, or whichever club.
Whatever traffic violations may happen in that particular area, yes, sir. Traffic is light that time of night,
Well, the car passes you
yes, sir,
and you pull out.
that's correct.
When does your light come?
I don't remember what street it was when my light came on. It was closer to First Avenue, it might have been closer to the embers. I'd have to look at the video again.
Well, was it say the word right, was it volitional? Or did the light come on because you flip a switch, or did the
Yes,
light come on? You
Yes, sir.
switch it.
I flip a switch for that light to come on, yes, sir.
And you don't think it was, when you pulled out, you don't think you put the switch on, you would have been driving down the road further?
No, sir, that's correct. I drove down the road before I came out.
So when she puts her blinker on to pull into the Chevron, you have your light on at that point.
Yes, sir.
So you pull up behind her, you get out of your car and you approach her,
Yes, sir.
and she says, "I'm drunk." Like words like that.
Yes, sir.
And she's driving.
Yes, sir.
So what specifically did you need in addition to that, to put her under custody?
Well, doing
I
a
mean,
standardized field sobriety test.
well, no, but did you have to do the field sobriety test? If
Oh,
she had,
yes,
if she had like said, no, I'm not gonna do that, would you let her drive?
Well, under the totality of circumstance, like based on what she answered, how she was talking, how she used her car for balance, a lot of that may have come into play because you can't just because she says before she gets out of the car, I'm drunk, I shouldn't be driving. That's the whole reason is not.
But
enough to
if,
put somebody under arrest.
if, it's conditional, all right? If you approach her, she broke down the window, whatever she did, you hear what she's saying, and she said, I'm drunk and I'm driving, because you saw her pull in,
Right,
would you have let her drive away?
if what,
Just if she said, I'm drunk and drive away, and she says, I ain't been out of the car.
would I let her drive away? I mean, she needs.
I wouldn't, but I mean, yeah, would you?
No, sir.
All right. So effectively, she would be in custody at that point.
Well, she's technically not in custody because she's not under arrest at that point.
Yeah,
She's
because you haven't
being-
said the magic words, but I mean, effectively,
Effectively, you're,
you would not have let her drive away.
no, sir.
So she gets out of the car and you start doing all these tests.
Yes.
Then you're talking to her. And you have said just now that effectively I would not have let her drive away.
Correct.
Why didn't you give her
Why didn't I give her what?
the Miranda warnings
When?
at
After I
that point
arrested
in
her?
time? Because she's in your custody. and she
After I
won't-
arrested her or before field sobriety?
No, before the field sobriety test. If she
She's not
wouldn't have,
technically under arrest at that point. She's being,
no, but that's a magic word. What I'm saying is, she's here and she says, and you would not have let her drive away. We agree with that, right?
correct.
So why didn't you say before you get her out of the car, unless you're just trying to accumulate evidence? You understand under Miranda, you have the right to remain silent. You have a right to have a lawyer. You didn't do that,
After you're under arrest, which she wasn't under arrest at that time.
but that's volitional on your part, right?
Honor volitional, what do you mean?
Voluntary on your part,
Voluntary to,
arrest or not arrest.
after you accumulate evidence, totality of circumstance, not just based on one thing that she said. No, we'll put her in handcuffs for that. After she's under arrest, after I tell her you are under arrest for DWI, at that point, you would.
But
read
it-
the Miranda warnings.
But if that's volitional, okay, it's a voluntary act or decision making on your point, based upon the accumulation of the evidence.
Correct.
And she says that she's drunk. And you won't let her drive away. So it's a decision that you make. Volitional, it's not like automatic. If it's a decision you make, it's volitional. And you go further, you're trying to increase the amount of evidence you have to support the arrest. That would be my guess.
She's not under arrest at that time, so
But-
Miranda's not required.
No, but you're taking it, you're saying there's a magic point in time when I have to do that. And up to that point in time, she's not under the arrest, but she has free to go if she's not under arrest.
Okay,
And you have her in custody because she's parked at the
okay,
7-Eleven or whatever that is.
okay.
And she says, I'm drunk. She's admitted that she's drunk.
Okay.
So,
Well, there's no way for me to know for sure that she's intoxicated until I gather more evidence. And after I gather all the evidence is when the decisions are made.
but your decision is that you don't have enough evidence at that point in time to require you to administer the Miranda? Or your decision is she ain't gonna get to drive away, but I want more evidence before I start giving her Miranda, because if I give her Miranda, she might not take these steps. Is that fair?
What is your question?
Well, is that a fair assessment of what you were thinking? I understand that you want to get more evidence.
Correct.
But if you won't let her drive away, she's in custody. There's,
Temporarily detained? Is that
well,
what you want to
no,
call
not temporary, because you won't let her drive away.
it? Well, she's not in handcuffs at that point. So she's not technically under arrest,
Well, let's pretend we go back to when I was in law school
okay?
and the professor is trying to teach me this stuff, okay?
Okay.
If you're in custody and you won't let them drive away, they're in custody. They're in arrest. You just haven't used the magic words yet. Is that fair?
I don't. think
Not,
that's the
you
decision.
may say that I haven't made up my mind to arrest her until I accumulate all the information. That could be what you're
That's
saying.
right, yes, sir.
But if you won't let her drive away, why did you administer the Miranda to give her a choice? Because it's a choice on your part. Because otherwise she couldn't drive, she could drive away. And I don't think you would have let her drive away. I mean, you'd be the nicest DPS trooper in the state of Texas if you did that. So, I mean,
I'd be putting a lot of people at risk on the road too.
well,
also in the same time.
that's exactly why I'm saying she's in
Right.
custody.
But she's not technically in custody at that point.
But the technical part
She
is,
didn't drive away is what happened. She stayed there. And she agreed to perform the field sobriety test.
but you didn't administer the Miranda unless I didn't hear it.
I'm gonna
Yeah.
object to ask and answer, Your Honor. He's repeating the same question.
I'm just trying to figure out,
Objection overruled. You may go forward.
it's okay to say that I went to some school and technically until I do X, she's not under custody.
She's not under arrest until
Yeah.
you say you're under arrest for the WI.
But that's something they taught you in school. In my going to school, what they taught us is if you're in custody, you can't leave and you're under arrest. So your decision that you haven't used the correct wording means that you can continue to do the test and you don't have to administer the Miranda. But it's your choice, it's your election. Whereas I'm saying if you're in custody, she can't go away. And why didn't you administer them? Because
I don't believe she was in custody at that point.
that's what you learned when you went to school.
Correct.
But conceding that it's what you were taught, and I mean, 22 years ago, you've been doing this a while, okay? Conceding that you were taught that, the fact, the procedural fact, what can't be denied is you did administer.
That's correct. I did not administer Miranda.
And you think because you you weren't obligated to administer the Miranda at that point in time because you wanted to accumulate more information.
I wanted to investigate more because you don't put somebody in handcuffs, or you don't arrest. If you're saying arrest begins the moment after she says, I'm drunk, I shouldn't have been driving. If you're saying that she should have been under
No,
arrest.
I'm
I mean,
saying
I
that-
believe that's the case.
what-
I disagree.
What I'm saying is if she's in custody, if she can't leave, and you're saying, and I'm not trying to twist your words, but you're saying she's not in custody until I make the decision over here, but I wouldn't have let her drive. So custody becomes the important thing as far as Miranda, at least the way I was taught.
We temporarily detained, so it's, so
But
you
she's
stop a car for speeding, are they under arrest at that point?
one if they admit to you that they're stoned or drunk, yeah,
Well, what if they're just speeding?
then you don't have the admission. You have an admission that she made. Yeah,
I mean,
did she say that she was drunk?
she did say.
She was driving. And the offense that you arrested her for was driving while intoxicated.
Yes, sir.
So she's admitted to the offense. Everything after that point in time is volitional on your part because you don't think you have to administer the Miranda until you tell her to cut or cut her. I guess is that what you're saying.
Right, yes, sir.
So the difference would be, I'm saying when in custody, and you're saying when I got enough information, and I didn't have enough information at that point in time.
That's correct, yes, sir.
Right, so that would be the two differences.
Yes, sir.
Sorry to take so long, but
Okay.
oh, did you arrest anybody else for GWI that night?
I don't recall.
I had a a friend that was a DPS trooper, and he set some kind of record for arrests.
You know,
Yeah, he's dead now, but I mean, he would do 2 a night.
really,
Do you have an average, or do you know, or
I don't really have an average on how many I get a night.
do you know how you've done it a year?
It varies every year. I mean, I've done as many as 35 or 40 a year, or I've done as little as here lately 2 or 3 a year, because I've switched roles within the department.
When you're, I think this is true. When you're a DPS trooper, you have the authority if you're in a uniform, I guess, you can arrest anybody inside the state of Texas for a traffic thing, anything related to traffic.
Well,
Is that
it
true?
depends. There's certain things you cannot arrest for, speed and open container.
Well, let me rephrase it.
Okay,
If I'm correct, you can give a ticket to somebody in El Paso
that's correct. Yes,
if you're doing traffic in El Paso, even though you're assigned here.
yes, sir.
So my question is, you're assigned to Jefferson County?
So my area is bigger than just Jefferson County now.
Well, how big is it?
Well, I cover Jefferson, Orange County, Hardin County, parts of Jasper County, and a little bit of Tyler County. Because I'm the commercial vehicle enforcement now, which is inspecting big trucks, dump trucks, stuff like that.
You do truck wrecks and stuff like that?
Yes, sir.
So you're, basically Southeast.
Yes, sir.
How long have you been in Southeast Texas?
For a long time.
When did you go to high school?
My entire career.
Huh?
Sorry,
Did
my
you go-
entire career, I've been in Southeast Texas. I started in Orange, County. I worked 5 years over there, and I've been in, Beaumont since '06. Current duty stations in Silverby.
Are you from Orange?
No, sir. I'm from, Coots, actually.
Okay. Let me check one thing.
Yes, sir.
Ms. Simmons?
The reason you actually follow a vehicle for a short period of time before initiating your traffic lights? And why is that?
To make sure see if they do a traffic violation. I drive on the shoulder.
And in this,
But,
in this present case, you saw the defective taillight.
yes, sir.
And prior to the dash cam or body cam, you did personally observe her swerving into the shoulder.
Yes, ma'am.
You performed a traffic stop. Would you say that is less restrictive than placing one in custody?
Yes, ma'am.
Okay, and you've been an officer for 22 years. Is there a difference between temporary detainment and custody?
Yes, ma'am.
Are you able to explain those to the jury?
Yes, ma'am. So temporary detaining is sort of like you get stopped for speeding or, not having your seatbelts on. It's pretty basic. Either you did or you didn't. Go back and run your information as long as you're not wanted. Issue a citation or a warning. Go back, give that to you. You either sign it or not, and then go on your way. But DWI is a little bit more complex because there's a little bit more involved. There's more factors to determine if somebody's actually intoxicated. So,
You testified that you heard the defendant say she was driving drunk. You also said to defense counsel that you weren't willing to make a permanent finding of intoxication without performing further steps. Is that correct?
yes, ma'am.
Okay. At that time, when you start performing the SFSTs and other tests, was she temporarily detained?
Temporarily, yes, ma'am.
Okay. Was she ever in custody at that point?
No, ma'am.
Temporary detainment, does that result in the triggering or the need for Miranda warnings?
No, ma'am.
So would you say that whenever you were conducting the SFSTs, you were just performing an investigation to see and determine if the defendant was in fact intoxicated. At which point you conducted the test and you had completed those, did you find that she would, or she showed signs of intoxication?
Yes, ma'am.
At that point in time, did you place her in custody?
Yes, ma'am.
No further questions?
Mr. Dahl?
I remember what is an SFT?
This SFST, standardized field sobriety testing.
S,
SFST.
sorry, S, F,
ST.
S, T,
Yes, sir.
okay, that's standard.
Standardized field sobriety testing.
And I'm not gonna rehash what we already talked about.
Yes, sir.
But I'm not gonna rehash it, of course. Thank you.
Yes, sir.
Ms. Simmons, you have any more questions? And may this witness be excused? Mr. Dahl? May this witness be excused? Okay, Officer Caraway, you're excused. All right, and you have a blessed day.
Thank you.
Ms. Simmons, you can call your next witness,
As I stated this time, call Steve Mays, Your Honor.
Steve Mays.
Yes, Your Honor.
Okay. Mays, would you please come forward? Raise your right hand. Ms. Mays, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down, you can take the witness stand, you can adjust the mic.
Good
Ms.
afternoon.
Ms. Simmons, you may proceed.
Thank you, Your Honor. How are you presently employed?
I am the director of the Jefferson County Regional Crime Line.
And I don't believe I asked, but just one more time for the record, could you state your name?
My name is Steve Mays,
How long have you been employed as a technical supervisor?
technical supervisor, about 8 years.
Okay. You said 8 years?
Yes.
Okay. And what are your current duties and responsibilities?
As far as technical supervisor goes, I monitor the toxilizer instruments for Jefferson County. We have a total of 3 of them. 2 of them are deployed in Jefferson County Jail. One of them is keep back at the lab, is kind of spare. I make sure that they're calibrated. I make sure that they're checked at least once a month. We're responsible for making sure that the operators, the officers being operated are properly educated, get properly licensed to operate it. I make sure that I get continuing education to make sure that I know how to properly operate. I sometimes repair instruments if they need it. And just basically maintain the program.
Can you tell the jury how long you've actually been the technical supervisor for Jefferson County?
Remember what year it was right offhand, but again, it's my entire career as a technical supervisor has been in Jefferson County.
And what is your education?
I have a bachelor's degree in biology and a master's degree in biology.
Can you tell the jury what special training you have had regarding the operation and maintenance for the intoxilizer, specifically the instrument model 9000?
Sure, there's a lot of education that's required for you to become a technical supervisor. A lot of classes and work with DPS, who supervises the intoxilizer program for every lab in the state. No matter who you work for, you're having to satisfy DPS that you know what you're doing and that there's a class that takes place at the University of Indiana, it's a week long. That's all nothing but that everybody who does this in Texas has to take, which I did. There's also a class with the manufacturer of the toxilizer in Kentucky that you have to go to. That's a week long to learn everything you can about the instrument, including how to repair it, things like that.
So during this time and then throughout your course of training, have you also learned the effects of alcohol in terms of a person's mental and physical faculties?
Yes,
Okay. Can the consumption of alcohol affect one's ability to safely operate a car?
yes.
How does alcohol actually affect one's ability to operate a motor vehicle?
Well, it affects the nervous system. It starts out kind of generally affecting things like your judgment, moral judgments, your ability to determine kind of what the right thing is and the wrong thing to do. It starts affecting things like vision, your senses, goals, typically the knowledge your senses, so you don't feel things quite as well, you can hear quite as well. You can get double vision. As you drink more, it can get into reaction time, things like that. And it can even eventually get into your autonomic system. So it's going to affect your breathing, it's going to affect your heart rate, it's going to affect your body's ability to control body temperature.
Thank you for that. Do you hold memberships in any scientific or professional organizations?
I do, yes.
Can you list those for the jury?
Southwestern Association of Forensic Scientists, Texas Association of Crime Laboratory Directors, the International Association for Chemical Testing.
Have you written or contributed to any professional publications and articles?
Not in Philadelphia.
Have you conducted any experiments on your own in regards to the Intoxilizer 9000?
Not on my own, but I've been part of experiments that were done with it that were controlled by UPS.
Have you conducted any experience on your own in regards to ones or the effects of alcohol on a person's mental or physical faculties?
Again, not on my own, but I've been part of it.
When were you first certified?
I don't recall the exact date.
How often must you recertify?
Every 2 years.
Okay. Do you know when you were last recertified?
Even last year, I believe, the year before.
Can you tell the jury if your certification?
I'm sorry.
Can you tell the jury if your certification was current on May 21st of 2023?
It was, yes.
And based upon your studies and your own experience, do you have a personal opinion as to the alcohol concentration at which a person does not have the normal use of her mental or physical faculties?
I do,
Okay. And why do you hold that opinion?
because of my education, everything I've seen, both personally, classes and experiments that have been done, and also the education I've had.
Are you familiar with the underlying scientific theory of the Intoxilizer 9000?
I am,
Is that theory considered valid by the scientific community?
yes.
Can you explain how the Intoxilizer instrument applies to that theory? What technique?
I can. It uses a instrument called an infrared spectrometer, a big word, but basically what it means is for the intoxilizer, when you take a breath into the intoxilizer, it's putting that into a special chamber and it's shining an infrared light through it. Then there are sensors at the other end that are tracking how much light gets through it and how much light is absorbed and which frequencies are. Every different chemical out there has a different combination of frequencies it absorbs and how much it absorbs. And it is also concentration dependent. So the more alcohol you have in there, the more infrared light it's going to absorb. And as I said, it does it at particular frequencies. So when those sensors catch that light at the other end, they know how much light is coming through and how much has been absorbed and what frequencies were absorbed. They can compare that to the pattern that ethanol, the alcohol in alcoholic beverage, is supposed to have. And determine, was that ethanol or was it something else?
What is that technique you just testified to? Was it properly applied in this case?
Yes,
Okay. Do you know a Jeremy Caraway?
yes,
And was Jeremy Caraway certified on May 21st, 2023 by the Texas Department of Public Safety as an intoxilizer operator?
yes,
Are you familiar with the intoxilizer instrument model number 9000 with the serial number of 90-001883?
I am.
How are you familiar with that instrument?
That is one of our instruments. Yes, yeah, so I'm very familiar with
And just to clarify, how many did you say there
it.
was?
We only have 3.
Has the intoxilizer instrument model 9000 been approved and or certified by Texas DPS?
It has, yes.
Is the intoxilizer instrument 9000, again, serial number 90-001833, I'm sorry, 1883. Is it certified by the Texas Department of Public Safety?
Yes,
And was that particular instrument certified on May 21st, 2023?
yes,
Was that instrument operated as part of the breath alcohol testing program that was certified by Texas DPS?
yes,
And as part of your duties, are you responsible for the maintenance and monitoring of this instrument?
yes, I am.
Can you describe to the jury the maintenance that involves or is involved with this instrument?
Most of the time, it's very little. It's a very reliable instrument. We check it once a month to make sure that it's working properly. We run a practice test to make sure. We have, at all times, there is what's called a simulator hooked up to it that contains a solution that is equivalent to a 0.080 alcohol solution breath, which is, of course, the legal limit for driving in Texas. Tested against that solution. It's tested against that solution during every breath test as well. Just make sure it's working correctly. If we find any problems with it, obviously we take it out of service and see what we can do about that. I have done maintenance on the instruments at times, came down breath hose, sometimes they'll go bad, something like that. Just kind of whatever it needs doing. In addition, if there's something serious that would go wrong with a breath test instrument, we can also send it back to the DPS lab in Houston, in Austin, where they have a specialist who does maintenance on.
And you say you do this maintenance or decalibration, if I'm speaking correctly, in regards to your testimony, once a month.
I do the check on them once a month. Yes,
Is-
calibration is not done.
Okay. Is there a specific date of the month that you do that?
I always try to do it early on. It's not specific, but I try to.
And was that, or what was the operational condition on this particular oxidizer instrument at that time?
It was operating.
What was the closest date after that, May 21st, 2023, that you had checked that intoxilizer instrument?
I did a calibration on April 10th of 2023, and I also did one on June 19th of 2023.
What, did that particular instrument require any repairs between the dates that you had checked it?
It did not. No.
Okay. Do you have an opinion, based upon your experience and training, as to the operational condition of intoxilizer instrument 9,001, serial number 90-001883 on May 21st, 2023?
It was operating.
And what is that opinion? Just that it was operating normally?
Yes.
I'm showing you what has been previously marked for identification purposes as State's Exhibit 4. Hand that off to you. Do you recognize this?
I do.
Okay. What is it?
This is the analytical report that the instrument prints out after a test is completed, a blood test.
And as part of the subject test, is the operator required to have the subject continuously in his presence for 15 minutes?
Before the testing even starts, yes.
Can you explain to the jury what the purpose of that is for?
I can. That's what we call a waiting period. When you're getting a breath test done, what you want is the air from the lungs. Because that's the air that's showing you blood alcohol content. The alcohol content in the breath comes from the blood. Because in your lungs, the layers of skin, the epithelial layer in the lungs, the alveolar layer, are very thin. So that alcohol evaporates out from the blood into the lungs. What you're trying to avoid is getting alcohol from the stomach. So if someone touches or something like that, that's coming from the stomach. You don't want that. It doesn't reflect the true alcohol level of the person. So 15-minute waiting period is designed to prevent any alcohol from the mouth or stomach from being involved in this breath. So you want to wait until you don't necessarily know when you stop someone when they took a drink. So you want at least 15 minutes since they had a drink of any kind before you take this test. You want to make sure that they haven't belched or thrown up or anything like that, because again, that could bring alcohol from the stomach. You don't want that. So 15 minutes is more than enough time for any alcohol in the mouth to dissipate, as long as nothing else happens during that 15 minutes.
Does the analytical report indicate that the proper operational methods and the testing techniques were followed in administering this test?
Yes.
And how can you tell that from observing that analytical report?
As far as the 15-minute waiting period is concerned, there's a line here at the bottom that says 15-minute waiting period completed. It says yes. That's something that the operator has to type in themselves.
So it's manual is what you're saying.
Yes, the test cannot continue.
And what is the calibrated verification solution?
That is the solution that I was talking about that is in the simulator connected to the instrument at all times. It contains a solution about a 0.08 solution designed to give that level of breath test, just to make sure that the instrument is working correctly and that it's reading alcohol breath solutions correctly. So it takes the vapor from that simulator and runs it through the exact same analysis that a breath test would get. So it sucks it in from the toxilizer into the toxilizer, test it just like it would a breath. And as long as it's reading correctly, we know that the instrument is working correctly. And it does this twice during every breath test. It does it once before you submit your first breath test to make sure that the instrument is reading correctly before a breath test is ever given. And it does it again after the second breath test to ensure that the instrument is still working correctly after the second breath test is given.
Can you tell the jury who prepares these solutions?
I do.
Okay, and how do you prepare them?
Basically, it's just a concentration of alcohol in water, ethanol in water, and we mix it in the correct ratio. We keep it at the lab.
Are the calibrated verification solutions periodically checked?
Yes, again, we're checking this every month. You know, we do checks in toxilizer, if something is out of range. We would make sure to figure out what's going on. If there's a problem with the toxilizer or a problem with the solution. If it's a problem with the solution, we can put that solution onto another toxilizer, see that it's an issue, and obviously we would change out that solution. And that is one of the things we do on these monthly checks is we change out the solution every month.
And how and by whom is the predicted value entered into the Intoxizer 9000?
So we put that in, so it's the legal requirement in Texas. It's the same on every toxilizer instrument throughout the state.
Does the analytical report reflect that the result of the calibrated verification system was within the tolerance of the analytical report value?
It does, yes.
And what happens if the report is out of tolerance?
So if it gets a reading that is out of its tolerance, it will stop the test.
Okay, and the analytical report says alcohol concentration. What does alcohol concentration mean?
But that is the concentration of the alcohol, ethanol in the breath of the subject.
And what steps should the operator of the Intoxizer follow if taking breath sample?
Basically, he just needs to do what the instrument tells it to. Again, you need to do a 15-minute waiting period. You're not putting anything in the mouth, they're not belching, they're not throwing up, they're not getting anything to drink, they're not chewing gum, anything like that. If anything like that happens, you start the 15-minute waiting period over. So you need 15 minutes cleaned before you start the breath test. After that, the operator just basically has to sign in, which they have a code to sign in. Only someone who is a certified officer is going to have that. If they're not certified, if they lose their certification, block that. They're going to have to, in the intoxilizer that they have done 15-minute waiting. It will require them to basically check a box, type in the word yes before it can go any further. They'll also have to sign their name, so they're signing their name to a registered government document. Other than that, they have to put what's called a mouthpiece into the breath hose, which is a disposable mouthpiece, so people are not putting, everybody's not putting a mouthpiece. And just tell the person when to blow. That's really not all they have to do.
Are there any steps that the instrument, when we're talking about the Intoxizer 9000, performs automatically?
Quite a number of them.
Okay, can you describe those to the jury?
I can. So the first thing it's going to do when you start up a breath test is do what's called an operational system check. And that is the instrument checking itself, checking all the voltages and everything to make sure that everything is where it's supposed to be. If it detects a problem at that point, it's going to shut the test down. Between every step, it's going to do what's called an air. It's going to suck in air from the room to purge out the instrument, anything that might be in there. And at the same time, it's checking that room air to make sure there's nothing funny going on with it. All in the air that's going to interfere with the test. So it's going to do that between every step. The next step comes at calibration verification, where it's checking that solution in the system. Then it's going to do another. Then it's going to do the first breath test. After the breath test, it's going to do another air. Yeah, all these air blanks, it's purging everything that was in there out of the instrument, and it's checking the room air to make sure that there's nothing that's going to interfere with the test. Then there's a 1-minute waiting period. It does another air blank. Then it does the second subject test. Another air blank, and then it checks that calibration verification again, just to make sure it's still reading correctly. Another air blank, then it does another operational systems check at the end. Make sure again, all the voltages and everything in the instrument are still running the way they're supposed to be before it signs off. That's the end of the sequence.
And Your Honor, at this time, state's gonna go ahead and, offer state's exhibit number 4 into evidence.
You gonna publish it?
I'm gonna tender to, I'm gonna grab it from right here. Tendering. Actually. Thank you.
Um, yeah. I just have a,
You like to take the witness on voir?
yes, sir, yeah, I just got a
Okay.
couple of questions.
Okay. You may take the witness on voir.
May I approach you?
Yes, you may.
That's yours.
No, sir. That is, Mr. Carroll, AC.
Oh, I thought it was G. Okay. Um. No, I just got a couple of questions.
You have any objections?
No, not to the report. I didn't know.
Okay. Okay. No objections, state's exhibit number 4 is admitted.
Fine. Fine.
Yes, you may.
And just for purposes of the record, state's exhibit 4 was admitted.
Yes.
What were the results of the 2 breath samples on state's exhibit 4? Do you have a copy or do you need?
I have none. The first breath test was 0.233. The second result was 0.224.
Were these results or were the results of these 2 breath samples within the allowed tolerance specified by Texas Department of Public Safety?
Yes.
What is the specified tolerance for breath?
So the 2 samples have to be within 0.020 of each other.
And what happens if those breath samples are not within that range?
Again, the instrument will detect that. It will shut the test down.
Are the subject's results an expression of the number of grams of alcohol per 200 liters of breath?
210 liters.
210 liters.
Yes, sir.
Are the results of, and that was Brianna Denise Kobos, breath analysis equal to or greater than an alcohol concentration of 0.08?
Yes, they are.
In your opinion, would a person with an alcohol level concentration of 0.233 with the subject result 1 and 0.224 have lost the normal use of her mental or physical faculties?
Anybody at that level.
I'm gonna pass the witness, Your Honor.
Mr. Dahl, you may proceed.
What's this down?
I just got a couple of questions.
Yes, sir.
How long have you been doing this?
I don't remember the exact date I first became Texas supervisor, but about 6 to 8 years.
16 years?
6 to 8. I've been in the forensics business at the Jefferson County lab for almost 19 years.
2004 or something like that.
2006, I started. Yes, sir.
Do you have any personal knowledge of the history of breath testing in Texas?
I do have some, yes, sir.
When I first started practicing law, the breath test minimum was 0.15. Is that true?
I believe that's true. Yes, sir.
And then we had a legislator come in and they said that 0.15 needs to be lower, so they lowered it to 0.12.
I believe it was lowered to 0.1 at one point. I'm not sure about 0.12, but possibly.
I think there was one between the
Yeah, there
two,
could be,
right?
yes.
So it goes to 0.10, then it goes to 0.08.
Yes.
Right? And there's a movement to make it 0.06.
In some places, I know, in Utah and in many countries in Europe, it was 0.05.
But the point to me would be that it's the same conduct that you're measuring with the breath test. Correct? Or do you agree with that?
Could you rephrase the question? I'm not sure what you're asking.
And when I started practice,
Yes,
it was 0.15. Now it's 0.08,
yes, sir.
but it's the same conduct, driving while intoxicated.
Yes, yes.
So what they have done is make it easier to prove by going from 0.15 to 0.08.
In my opinion, they've learned more about at what point someone starts to lose the ability to safely operate.
Well, that could be your opinion, but I mean, objectively, they made it easier to prosecute, right?
I suppose they have, yes, sir.
Is the machine that you judge, the toxilizer 9000,
Yes, sir.
is that the latest on the market?
I believe it's the latest on the market from this particular manufacturer. There may be other manufacturers that have manufactured something recently.
Who makes the decision as to what machine is going to be used for Texas? Is that individual to each county or DPS?
BPS.
So the DPS has said that everybody's got to use the toxilizer 9000 in Texas.
Everybody does. DPS decides if a instrument meets the requirements in Texas and approves it. Theoretically, I suppose they could approve more than one instrument, but as far as I know right now, it's the toxilizer 9000.
And that decision comes out of Austin.
Yes, sir.
No further questions. Thank you.
Ms. Simmons?
Just briefly, Your Honor.
Yes.
Are you aware in the state of Texas that a defendant is deemed intoxicated if their BAC or blood alcohol concentration level is greater than 0.08?
Yes,
Were the results on this test 0.223?
yes.
No further questions, Your Honor.
I don't have any more.
Okay. May this witness be excused?
Yes, Your Honor.
It's okay with me.
Okay. Mr. Mays, you're excused. You may step down and you have a blessed day. State you'd like to call another witness?
At this time, Your Honor, the state rests.
Okay, ladies and gentlemen of the jury, what we're gonna do right now, we're gonna take a 2-minute break. And, will everyone please stand as the jury exit the courtroom? Will be in recess?
I think they're gonna be excited.
You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23CCCR 0842. Case is South State of Texas versus Brianna Denise Cabos. Let the record reflect that Ms. Cabos is present in court with her attorney. Attorney Peter Dahl, state is present with assistant district attorneys, Attorney Haley Simmons, Attorney Andrews Hubel, and Attorney Shane Hilton. Let the record also reflect that the jury is now present and seated in the courtroom. The state has rested their case. Mr. Dahl, you may proceed.
The state haven't rested, we rested.
Okay. Okay, ladies and gentlemen of the jury, the state has rested and the defense has rested their case. And so with that being said, we're in the process of preparing a charge. And what the charge is just the law that the court is going to give to you. We have to give you the law first. And then after we read the charge, then the state and the defense will do their closing argument. After they do their closing argument, then the case will be in your hands. So at this time, we have to have what is called a charge conference. And so we're gonna ask everyone to please stand as the jury exits the courtroom. If you need any water or coffee, just let the bailiff know. Okay. Okay, go big and recess as we prepare for the charge conference. You may be seated. We'll proceed at this time with the trial of this case. Let the record reflect that the attorney for the state, attorney for the defense, and the defendant is present in the courtroom. All members of the jury are present and seated in the courtroom. At this time, ladies and gentlemen, I will read to you the charge of the court containing the law applicable to this case. The defendant, Brianna Denise Cabos, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place, and the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed. The offense is alleged to have occurred on or about the 21st day of May of 2023 in Jefferson County, Texas. The defendant having stood mute, the court entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances, or any other substance into the body, or by having an alcohol concentration level of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes but not is limited to streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Alcohol concentration means the number of grams of alcohol per 210 liters of breath, 100 milliliters of blood, or 67 milliliters of urine. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 21st day of May, 2023, in Jefferson County, Texas, the defendant, Brianna Denise Cabos, did then and there operate a motor vehicle in a public place while the defendant was intoxicated, and that the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then you will find the defendant guilty, unless you so find beyond a reasonable doubt. If you have a reasonable doubt thereof, you will next consider whether the defendant is guilty of the lesser included offense of driving while intoxicated. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 21st day of May of 2023 in Jefferson County, Texas, the defendant, Brianna Denise Cabos, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, then you will find the defendant guilty of driving while intoxicated. Unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors have satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant's guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question a bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberations, it must be reduced to writing, signed by your full person, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror nor consider it yourself in arriving at a verdict. Our law provides that the defendant may testify on their own behalf if he or she elects to do so. This, however, is a privilege accorded a defendant, and in the event he or she elects not to testify, that fact cannot be taken as a circumstance against him or her. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into considerations for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of this charge is the verdict form. There are 3 sections on the verdict form. Your foreperson will sign only one section. At the top, it states that we, the jury, find the defendant not guilty. If that is your verdict, your foreperson will sign here. Or the middle portion states, we, the jury, find the defendant guilty of driving while intoxicated and blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed. If that is your verdict, your foreperson will sign on the middle. Or at the bottom, it states, we, the jury, find the defendant guilty of the lesser included driving while intoxicated. If that is your verdict, then your foreperson will sign on the 3rd line. Does everyone understand? Okay. State, are you ready?
This time, Your Honor, the state will waive its right to open and reserve.
Mr. Dolph, you may proceed, and you have 20 minutes, and the court will be keeping time. You can turn the podium toward them. Okay.
Now, up to this point, I was all been doing it. And then you have to make a decision. And the counsel for the state, myself, we're going to try to persuade you to make certain of those decisions a certain way. So bear with me. I don't think I'm going to go over 15 minutes, but we're going to see. Now, y'all are going to get a copy of this. The first paragraph reads that the defendant, Brianna Denise Cobos, stands charged by information of the offense of driving while intoxicated while driving, offense of being intoxicated while driving or operating a motor vehicle in a public place. And the analysis of the specimen of the defendant's blood showed an alcohol concentration level of 0.015 or more at the time this analysis was performed, and the offense is alleged to have occurred on or about the 21st day of May, 2023 in Jefferson County, Texas. The defendant, having stood mute, the court entered a plea of not guilty. Right? This is the sort of what I think is the key paragraph. It's my contention, the defendant's contention, that Brianna was in custody of the DPS trooper at the time he got out of his car. I guess she goes in the window. And her car at the Chevron 7-Eleven neighbor. If she was in custody at that point, our contention that he should have administered Miranda. Now, Miranda, you have to go back to the 60s. And what Miranda said was that if the cop, a law enforcement officer, or a district attorney, or some person that has control custody, then that individual is obligated to at least admonish the defendant, tell the defendant that he has the right to.
Yeah. Yes. Hold on a minute. You may be seated. The court is back in session. The cause number 23 CCCR 0842, case of Styles, State of Texas versus Brianna Denise Cobbles. Let the record reflect that Ms. Cobbles is present in court with an attorney Peter Dahl. State is present with Assistant Criminal District Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. Let the record reflect that the jury is now present and seated in the courtroom. And ladies and gentlemen of the jury, the court had read to you the court's charge. The court noticed a typo. It needed to be corrected. And it was one word. The one word, it had blood and should have been Brett. And so it was on 3 pages. The first page, I'll just read the paragraph where that word is found. It says the defendant's Brianna Denise Cobbles stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place, and analysis of a specimen of the defendant's breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed. The offense is alleged to have occurred on or about 21st day of May 2023 in Jefferson County, Texas. The defendant having stood mute, the court entered a plea of not guilty. And on page 2, paragraph 3, it states, now bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 21st day of May of 2023 in Jefferson County, Texas, defendant Brianna Denise Cobbles did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, and analysis of a specimen of the defendant's breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then you will find the defendant guilty as charged. And then on the verdict form, in the middle, it states, we the jury find the defendant guilty of driving while intoxicated of Brett, and Brett showed an alcohol concentration level of 0.15 or more at the time of analysis. So the word blood was incorrect. It should have been Brett. Okay. At this time, we will continue with the closing argument. And Mr. Dahl, you may start from the beginning. You may proceed. I'm keeping your time.
I'm gonna, I'm going to keep myself, although I didn't get very far, but I'm do leave for him. What we're supposed to do at this stage is interpret for y'all the charge. He is going to have an interpretation. I want to have an interpretation. And we're supposed to give you some kind of guidance as to what you do when you go in there and deliberate. Because there's not going to be anybody there in the room when you deliberate. The bailiff's not going to be there. The judge ain't going to be there. Neither will the prosecutor. So what I try to do when I'm in this situation is try to point out to you the things that I think are of some importance. Now, in the first paragraph here, it says that the defendant, Brianna Denise Cobbles, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. And if you delete this sentence, the offense is alleged to have occurred on about the 21st day of May, 2023 in Jefferson County, Texas. Defendant having stood mute, fortunately plea of not guilty. The part of the sentence that I'm saying that you delete is, and that the analysis of the specimen of the defendant's breath showed an alcohol concentration level of 0.014 or more at the time the analysis was performed. Miranda is enshrined in the law. It is cited on TV shows, courts all over this country. And if you're in custody, then they're supposed to admonish you on the effect of Miranda. And if the officer, the trooper, did not believe the header in custody, it is not his decision. It's the jury's decision. And what we're asking is that if you delete the, from that part in time, subsequent to that, you could find her guilty of driving while intoxicated. But if you delete that particular phrase or part of the sentence, when you delete the part about the, that the blood level was at 0.015 or breath level was at 0.015 or higher, that has an effect on the punishment. And it's not going to be, y'all aren't going to do the punishing, it's going to be the judge does the punish if you find her guilty. But the judge is going to act based upon y'all's verdict. And she was in custody. If you can't leave, you're in custody. And he wasn't going to let her leave. He just wanted to accumulate more evidence to use against her when he'd already decided that he was going to arrest her. Not a bad thing, it's not a good thing, it's just that's what he was going to do. And we're asking you to delete that part because it's within y'all's discretion. If you delete that part of the charge, it's also deleted over here. And it's the same language, 0.05. And when you go to the jury verdict, sorry. There's three. One is you find her not guilty. That's a discretionary call with the jury, but y'all make up your mind, return a verdict. If you decide that she's guilty, and you don't do this, you don't do the not guilty. You go either here or here, because here's the 0.015 language, and here's the language that says she's guilty of DWI. That will be up to y'all to do it. I'm submitting to you for your consideration that if you consider that she was in custody, then it should be excluded, and that's a way to put the check on police power. And juries, judges, lawyers bring that to their attention. It's nothing either bad or good, it's just the way the system is. So if you bring that into your deliberations and you delete or find the bottom where you just guilty of DWI, that's what the logical implication that follows your decision to delete that account. Because there's basically 7 counts. You know, if you took back and you looked at each one of the elements, there's 7. And we're asking not to have that 7th one, but the one that would be the 7th, not to have that one found to be true, found guilty. And it's been pretty much a short trial. Y'all have been pretty attentive, and I hope I haven't bored you, and I hope you understand why we're here. I'm just asking you to do that because it's best in the American way. Thank you. Thank you.
Ms. Simmons?
Okay, who's the board? Good evening, at this point. Thank y'all for y'all's patience and y'all being so attentive about the try this case. As Mr. Doyle said, it was a fairly quick trial. I know y'all are here past 5, but I appreciate y'all considering everything before you, all the evidence you have. I want to kind of pinpoint to the driving while intoxicated. I put the elements up for you for your convenience again. Again, I apologize. Mr. Doyle and defense, they basically just stipulated that the state has an error in driving while intoxicated. He's asking that you omit the without or with an alcohol concentration level of 0.15 or more. He is not arguing the defendant's identification, which was testified to by State Trooper Jeremy Caraway. He's even stipulated in opening the date is not of issue, May 21st, 2023. We've heard that from Jeremy Caraway, the State Trooper. We've also heard it from Steve Mays, who performed the intoxilizer analysis. Jeremy Caraway comes in and he has testified as to the fact that this happened in Jefferson County, Texas. He's testified to visually seeing and observing her operating the motor vehicle, which he also testified to the car being such, in a public place. Now, when you're looking at the jury charge, and like Mr. Doyle says, you get to bring this back. A public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools and such. This is the law. This is the definition of a public place. You saw it on the dash cam. You saw him attempting the traffic stop. He initiates it. They stop in a safe place at the gas station. It happened in a public place. And again, defense is stipulated to such. While intoxicated. We dug a lot in Board Diary yesterday. I'm sure y'all heard me say it a million times. You're probably tired of hearing me say it. 3 definitions of intoxication. The loss of mental faculties, the loss of physical faculties, and a blood alcohol concentration of greater than 0.08 or more. I submit to you that I have proved all 3 of those. Trooper Caraway got on the stand. He testified to the standardized field sobriety test, which we've used SFSTs and such simultaneously throughout the trial. He testified to seeing her wobbly on her feet. She could barely form coherent sentences. This is an individual that was driving on a public roadway. You didn't see a wreck. You didn't see a crash. But what happens if we don't hold someone accountable when they're on the roads, in the same roads that your children are getting taken to school on? The same roads you're driving to work on in the morning. Y'all have the very unique ability to go back into that deliberation room and come to a unanimous agreement and hold the defendant accountable. This is your home. This is your family. These are your friends on these roadways. I'm not misrepresenting the fact that the defendant here is young. I understand that. You heard her testify, and this is in State's Exhibit 3. Well, not testify, I apologize. You heard in State's Exhibit 3 her own statement. I am always drunk. If we don't hold her accountable now, what happens in the future? What happens if she gets on the road and she does this again and somebody is in fact hurt? What happens if it's your brother, your child, your parents? This is why we do what we do. Accountability. I am a firm believer. I'm a firm believer in protecting the citizens of Jefferson County, Texas. That's why we're here. And y'all have the unique ability to find that. But that brings me to the last element, and that's the enhanced element right here, alcohol concentration level of 0.15 or more. State's Exhibit 4, which was admitted, and let me tell you, in the jury charge, it does specify that you're able to ask for these. You have access to them. If it's admitted, you can send a note signed by the foreman. You can ask for it. You can specifically ask for State's Exhibit 1, State's Exhibit 2, 3, 4. State's Exhibit 4. We had Trooper Caraway testify to this. We had Steve Mays testify to this. On redirect, you heard Steve Mays himself admit that the legal limit to deem one intoxicated by law in the state of Texas as 0.08 or more. He testified that she had a blood alcohol concentration of 0.233, and on the second test, 0.224. That is barely under 3 times the legal limit. I submit to you, we met the burden of 0.15 or more. Nothing else is being argued. Defense counsel has already told you, you could in fact find her guilty of driving while intoxicated. But as I stand here before you, and I tell you everything that you saw, she does in fact admit she was driving drunk. We see that. You see the standardized field sobriety test. You see her wobbling on her feet. She can barely step forward. You see her unable to hold her leg up. You see these things. That person is operating a vehicle in this county in which you live. It starts with you. Truly. Accountability. And that is what I ask for. And when you go back there and you deliberate, I ask that you unanimously find, right here, we, the jury, find the defendant guilty of driving while intoxicated, and Red showed an alcohol concentration level of 0.15 or more at the time of driving. I trust your judgment. I trust your patience. I trust that you have listened to everything before you today. And I trust that you go back there and in your deliberations, and you make the wise choice in protecting Jefferson County, where you live and your family lives, and hold the defendant accountable. Thank you so much for your time.
Ladies and gentlemen of the jury, at this time, the evidence, the court's charge, and the closing argument of counsel are before you. I'm going to hand this charge to the bailiff with the verdict form. They will be left with you in the jury room. Once all members of the jury are present and assembled in the jury room, the case is formally submitted to you and you may begin your deliberation. Now, before you begin the deliberations, I must inform you that in a misdemeanor jury trial, we have 6 members of the jury. If you notice, we have 7. The reason why we have 7 is because one of you, one person is the alternate juror, and the alternate juror is not allowed to go into the jury room unless something happens, and then that alternate will replace one of the jurors who's on the jury. And so the alternate in this case is Romero Cavazos. Mr. Cavazos, okay. Now, Mr. Cavazos, you're the alternate. You can remain in the courtroom, or if you like to sit in the hall, you can do that as well. So at this time, I will hand the charge to the bailiff, and will everyone, the 6 jurors, would you please follow the bailiff into the jury room? And the court will stand in recess until the jury reaches a verdict. At this time, we'll be in recess. Hold on a minute. Okay. Let the record reflect, okay, we back in session and cause number 23 CCCR 0842. Case of South State of Texas versus Brianna Denise Cobbles. Let the record reflect that Ms. Cobbles is present in court with Attorney Peter Dahl. State is present with Assistant Criminal District Attorneys, Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. I have received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? You may be seated. Let the record reflect that the attorney for the state, the attorneys for the defendant, all members of the jury are present and seated in the courtroom. Foreperson, have you reached a verdict in this case?
Yeah, Your Honor.
Is this verdict unanimous? That is one that is agreed upon by all the jurors. Okay, Mr. Bailiff? Mr. Bailiff, could you please get the verdict? The whole, give me the,
Hold on.
Ms. Cobbles, would you please stand? Okay. We, the jury, find the defendant guilty of driving while intoxicated, and a breath showed an alcohol concentration level of 0.15 or more at the time of the analysis was performed. And is this verdict one that was agreed upon unanimously by all members of the jury?
It was.
Okay. Will anyone like the jury to be polled?
I would.
You will? Okay. Now, when I asked if he wanted the jury to be polled, I'm going to ask you a question. And I need to ask each juror if this is your verdict. Okay. Dudley Swallow Jr. Is this your verdict? Priscilla Marie Castillo, is this your verdict? Maisha Wheaton, is this your verdict? William Traeger, is this your verdict? Jason Franks, is this your verdict?
Yes.
And Ronald Coleman, is this your verdict? Okay. You may be seated. Ladies and gentlemen of the jury, on behalf of the citizens of Jefferson County, on behalf of the staff here in County Court at Law Number 2 of Jefferson County, I'd like to thank you for your time and attention. I know that you were very attentive because I was paying attention to you during the duration of this trial. Your jury service is greatly appreciated, not only by me personally, but also by all the citizens of Jefferson County, and I'm sure by the attorneys and the defendant in this case. Now, your jury service is complete, and the attorneys may want to ask you some questions once you leave here. You can answer the questions if you want, or if you decide not to answer any questions, you don't have to answer any questions. That's a choice that you have to make. Now, our district clerk's office is closed. We will be able to get him some letters or anything if you need or they have to get in contact with the district clerk's tomorrow? Okay, so you'll be required to get in contact with the district clerk's office on tomorrow. If you need anything from the district clerk office, they will show that you did appear here today and that you served as a juror in this case. Now, I know that when you came to court yesterday, and when the jury was actually picked, or before the jury was picked, before you even came into the courtroom, you looked over the top of the door and you saw my name. You said, "This is Judge Holmes' court, County Court of Number 2. I'm in the right place." I said that to say this is not my court. I'm only a public servant, serving the citizens of Jefferson County. You're the citizens of Jefferson County. So I'm serving everyone who is citizens of Jefferson County. And anytime that you're in this area of Jefferson County, Court at Law Number 2, you can have a seat in your courtroom. And you can sit in that area behind the wall. We call that wall the bar, the little wall right there. You can sit in that area. In that area, we call it the peanut gallery, but it doesn't mean you can bring peanuts in here to eat, because as I mentioned on yesterday, this is not the Texas Roadhouse. But you can come have a seat in the peanut gallery and see what goes on in your courtroom, and see what goes on in Jefferson County. And if you're unable to come down to the courthouse, you can see what goes on in County Court at Law Number 2, Monday through Friday on YouTube, okay? And so I'd like to thank you for your time and your attention. The bailiff have some letters for each and every one of you. And again, thank you for being here today, and thank you for being here on yesterday. As I also mentioned, I usually give handshakes, but we still have COVID and norovirus and some of these other things in our community. But I will give what I call an air handshake to each and every one of you. So again, ladies and gentlemen, thank you for your time and attention. Oh, make sure you return the badges. You are excused. You can put them on there and the bailiff will get them from you. You are excused. Everyone, please stand. And everyone y'all have a blessed day. Okay? Court is in recess. Okay, now we're gonna have to reset this case for punishment. We're gonna order a PSI to be done by the probation office or the probation department. So let's reset it. They usually need at least 30 days. Okay. Yeah, you may be excused. Oh, we're going to, she's gonna give you a date. Once she gives you a date. Okay, let's give you a copy of something else, okay? All right, this will conclude the trial. Cause number 23 CCCR 0842. State of Texas versus Brianna Denise Cabos. We'll revisit this case again for punishment. Do we have a date?
April the 11th.
Okay, April 11th. Case will be reset to April 11th for punishment. Okay. Thank you, Kim.